Adrian Soto. Mr. Woodard, it's been a long time since we've seen you.
Good morning.
Good morning.
Just before we begin, I do have layers I've shown to the state if I can provide them to the court.
Let me read this very quick. No, they're not. All right. And my understanding, he entered a plea in 2 cases. Is that correct?
That's correct, Judge.
All right. The court is calling 2020 CR 2993 and 2023 CR 043W, State of Texas versus Adrian Soto. Could I have parties announced for the record for the state?
For the record, state.
Vince?
Dave on here. What is Mr. Soto?
Are you Mr. Soto? And cause number 2020 CR 2998. You enter a plea of no contest to burglary of a habitation with intent to commit assault. According to the plea bargaining agreement, punishment is to be assessed at 8 years in the prison, and the state is closing your application. And cause number 2020 CR 361. You entered a plea of no contest to the offense of assault, bodily injury of a security officer. According to your plea bargaining agreement, the state is requesting that punishments be assessed at 8 years in the prison. They're closing your applications. Have both parties had a chance to review the PSI report, state? Vince?
I have, Judge.
Any objections to the PSI report, state?
No objection.
Defense?
No, Your Honor.
All right. Any witnesses, state?
No from the state.
Defense?
No, Your Honor, aside from the letters that I provided.
All right. And for the record, the court has reviewed the letters that have been presented. The court will hear arguments, state?
Your Honor, based on the defendant's criminal history, he does pick up these felony cases as well as multiple misdemeanors that are also pending involving the same family. The defendant's conduct is escalating and continues to terrorize the family, including the complainants on this case, as well as his brother, his children, and his mother. And the burglary for habitation, burglary to a habitation case, the defendant's alleged to have entered the house through a open window, through an unlocked window, and grabbed the child from where he was sleeping at 3 o'clock in the morning. He's shown a disregard for safety and welfare of the complainant as well as the children in the household. And it's the state's fear that if the defendant were granted probation, he would continue to contact the family, continue to violate any no contact orders that would be entered. I believe it's the only way to ensure that this.
Hold on a second. Did you catch that? Prosecutors are alleging that Soto climbed through a window at 3 a.m. and grabbed a sleeping child. That's the kind of detail that immediately changes how a judge views a defendant. This hearing isn't just about criminal charges anymore. It's about whether the court believes the community and this family need protection.
Safety and the welfare of the complainants are two sentences into
Defense?
Judge, after the PSI and also talked to Mr. Soto this morning regarding the impact statement as provided in the PSI, and asked him this incident if he had any contact with the complainants. Since the incident, he stayed away from it. He does have 2 children with the young lady. He hasn't seen the children because of this incident, but he has not gone around them or their household. So I think he's shown to stay away from them. And I don't think he needs prison to stay away from them. Since he's been on bond, since his case was being pending, he stayed away from that family. Also, Judge, if you look at his prior history, he does not have any convictions for misdemeanors or felonies. He's 25, he is working, he has support, he has family members here in court with him this morning. They have the letters all provided to him. I think when we pled on the case, Judge, the court asked him if he was experiencing any substance abuse issues at the time of the offense. He was truthful with the court. He said, yes, Judge, I was under the influence. I also asked him this morning if the court did test him, how would he come up? He explained to me he would come up negative. He has not been using any type of substance. He's been on bond since his case has been pending. He's working as a painter. He's not on child support for the children, but he is going to place himself on child support to start contributing to their well-being. Also, Judge, the TAC evaluation, I noticed that it is recommended inpatient treatment. The court did grant his application for deferral. We would ask the court to first see how he does through intensive outpatient treatment, because he's shown that he can stay drug free. And I do think that he would need some true assistance. You know, he's been doing this on bonds. We would ask the court if the court did grant his application for deferral to replace the intensive outpatient treatment prior to placing him in season. Accept the responsibility for both offenses and collections cases, and now we're here before the court asking the court to grant his applications for deferral.
All right, so this is the court's issue. Not really an issue. These are things that I think of. All right, so he has a felony offense, and I'm assuming this is being taken into consideration. The violation of an order, protective order. That's from December 31st, 2019. Burglary that he pled to is...
Now Judge Boyd is doing something experienced judges do exceptionally well. She's stepping back and looking at the pattern, not just the individual crimes. One arrest might be a mistake. 2 arrests might be bad judgment. But when cases start stacking up year after year, judges begin asking a much bigger question. Is this behavior getting worse?
It's from December 27th, 2019. So, let me go in order. So he has a continuous violence case that's December 14, 2018. I'm not saying it's true because nobody pled to that. That's what he's charged with. Then after that, you would think something would click. Hey, I just got arrested. Because I know he would have gotten arrested on that and made bond. And he would have gotten an attorney. So you would have thought that something would have clicked with that. But what ends up happening is on December 27, 2019, he does this burglary. Then you would have thought something clicked with that. But then what ends up happening? He picks up the he picks up the violation of the court order or bond order, protective order, on December 31st, 2019. And you would have thought that it would have been like, hey, I need to be on my P's and Q's because I picked up all these felonies. I understand relationships, and sometimes people don't love each other anymore and they have children and they got to make it work for the children, or they got to stay respectful to each other because they got to raise children together. And as everybody know, even though people say, yeah, we only need to be with each other for 18 years, but people know sometimes you need to be with certain children till they're like 25 or 30. I understand that. Then what ends up happening? He ends up picking up another case that he pled to, which is the assault case, on September 17th, 2022. So he has some issues. And I don't think that probation at this time is appropriate for him. Is he on GPS?
He is, Judge, and since he's been on GPS, he has not violated the GPS.
Oh, because he's on GPS because of this. And I'm not the judge who gave him probation for continuing to pick up cases. Some other judge did that, and the only thing I came back to do was probably add the GPS so that everybody would know where he was.
And there it is, the defense's strongest argument. Soto has reportedly stayed out of trouble while on GPS monitoring. But here's the legal reality. Electronic monitoring isn't rehabilitation, it's supervision. The judge now has to decide whether good behavior under strict monitoring proves real change, or simply proves he knows he's being watched.
So, I'm not inclined to give him probation. I'm not going to give him probation. I'm going to sentence him, and I will retain jurisdiction. So, in cause number 2020 CR 2998, court will find you guilty. Court will sentence you to 5.
Oh, you can hear it in the judge's voice. When a judge says, "I'm not inclined to give probation," that's courtroom language for, "I've already made up my mind." At this point, the defense isn't fighting for probation anymore. It's hoping for the most favorable sentence possible under the circumstances.
30 years prison. Give you credit for any time served. There's a $1,500 fine. Time and money will run concurrent. This will run concurrent with 2023 CR 0463W, taking consideration 2022 CR 3661, 2021 CR 3086, night mag number 679462, following county court cause numbers 634960, 6048888, 630200, 634987, 634989. There's an affirmative finding of family violence. There's to be no contact with Augustine Olvera, Olvera, Elvira Olvera, Galilea, Gaillia, Olivera, and John Mello, Mellow. Give you credit for any time served. And that cause number, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. On cause number 2023 CR 0436W, court is finding you guilty, sentencing you to 5 years in the prison, give you credit for any time served. This will run concurrent with 2020 CR 2998. There's to be no contact with Bentley, Bentley, Beer, Ber, Garden. Court will give you credit for any time served. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand? All right, we can go off the record. I'll retain jurisdiction.
Both cases, yes.
Sometimes, you know, it is about it's always about rehabilitation, but it's also about protecting the community, and it's also about punishment. Sometimes people think the justice system isn't about punishment, but really, all these cases, there's an air of punishment involved, but hopefully rehabilitation. I know you probably think this is the end of the world. I came in here, I'm going to prison, but you're young, you still have a chance to get your life together. Please don't go to prison.
This may be the most important lesson from the entire hearing. Judge Boyd reminds everyone that the justice system isn't built on just one goal. It's a balancing act between punishment, rehabilitation, and public safety. And in this case, the court decided that protecting the community outweighed giving another chance on probation. What do you think? Did the judge get it right, or should Soto have received one final opportunity to prove he could change?
And get a bunch of tattoos. Because you're clean shaven now, please let it stay that way, okay? All right, thank you.
Thank you.
And State, if you can get the dismissals.
For Adrian Soto, today's hearing ends with prison time, but not necessarily the end of his story. The judge made it clear that at 25 years old, there's still time to turn things around. The question is whether this sentence becomes a wake-up call or just another chapter in a cycle that's already lasted far too long.